Over the past year, this country has experienced some of the deep, painful, and systemic injustices in our society. I don't need to tell you the names. The death of George Floyd, Daniel Prude, Dante Wright, Breonna Taylor, Eric Garner, and the list goes on. And so many other unarmed men and women of color, unfortunately, have died at the hands of police. And this has rekindled a flame of righteousness and righteous indignation that has been smoldering for centuries. We are in the midst of a racial reckoning in this country. And while these killings are not new, but with more cell phones and video recordings, more people are witnessing the unbearable truth that many of us have known for a very long time. Last month, we saw a police officer convicted for the murder of George Floyd. But the Derek Chauvin verdict is exactly the exception that proves the rule. Accountability in these cases is rare. In most cases, officers who kill individuals are not even charged with a crime, let alone convicted of one. In fact, according to the Mapping Police Violence Project, less than 2% of officers are charged, and only about a quarter of those are ultimately convicted. At its core, the system was built to protect and shield officers. In fact, in New York, it is exceedingly difficult to prosecute police officers who kill civilians because of an expansive justification law that gives officers extraordinary wide latitude to use force, diminishing prosecutors' ability to hold police accountable, even when officers may be at fault or when the death was not necessary, totally preventable. And today we are taking an important step to change that reality. And so along with my colleagues here today, I am introducing and announcing legislation to change New York state laws that govern police violence and accountability through the most far-reaching reforms in the use of force laws in the nation. The centerpiece of this effort is to amend the use of force law from one of simple necessity to one of absolute last resort. And under the current law, police officers are legally justified in using deadly force, not only to defend themselves or others, but also when they reasonably believe that an individual has committed a particular crime. So let me give you an example. So under our current law, an officer who suspects an individual attempted to commit the crime of arson, even if that attempted act occurred 2 weeks prior, that officer could be justified in using legal force to arrest that person or prevent his or her escape. In a situation like this, an officer can use the justification statute as a means of avoiding the legal liability for using force. And even in cases where the officer is allegedly defending themselves or others, where there is essentially no consideration of whether the officer could have used alternative means to resolve the situation and preserve the individual's life, such as give a warning, such as de-escalation, such as communication, such as distancing the individual. Did they seek to de-escalate the situation? Did they exhaust all practical and reasonable alternatives? Did their own conduct create the circumstances that are later used to justify employing deadly force? Our goal today is to preserve lives by making sure that under the law, lethal force is the last resort. And while there is legitimate reason why police officers have some special protections, those protections should not preclude them from being held accountable when they needlessly take the life of another or unnecessarily use excessive amounts of force. If there is a way to accomplish the officer's objective short of lethal force, we should absolutely demand that they take that other path. This bill will explicitly require officers to consider whether the same end can be accomplished with non-deadly force or no force at all. It will mandate that an officer only use deadly force when they truly believe it is necessary, and that a reasonable person in the same position would also hold that belief. It will ensure that lethal force is deemed appropriate only when a threat is truly imminent, which is what officers are already taught and is already outlined in their patrol guide. So this is an attempt to codify that which exists in an officer's patrol guide. I want to be clear. Now, this is not going to change those split-second decisions that officers must make. Split-second decisions that law enforcement must make in the city of New York, particularly when confronted with a dangerous situation or when their life or the life of another individual is being threatened. It will not change those situations. There are reasonable protections that officers need in situations like those. And that, my friends, should not change and will not change. That is not what these reforms are about. But there are fact-specific cases where officers could have used non-lethal force to contain the situation or restrain the individual or to effectuate an arrest. In addition to the reforms, this bill will also establish a new criminal offense and penalties for police officers who employ force that is grossly in excess of what is warranted under the circumstances and where that force causes physical injury or death. And that means that even if it's determined that an officer is justified in using some force, if they are found to have used far more force than is necessary, they can potentially face a new criminal charge. And the severity of that crime depends upon the circumstances and depends upon the injuries caused. But it would give prosecutors a critical additional tool to hold officers accountable for wrongdoing. It's a gray area that has been outlined and identified by prosecutors in our office charged with investigating police-related killings. In just a few minutes, you will hear from Gwen Carr, the mother of Eric Garner. Eric Garner was killed in 2015 after an NYPD officer used an illegal chokehold on Mr. Garner, who repeatedly told the officer he could not breathe. We cannot be fully certain about how these new reforms would have applied in that case, because the grand jury minutes, as all of you know, were never unsealed despite our efforts. And that's another area of reform that we need. We need more transparency in the grand jury process because we need to know what happens behind closed doors. But what we do know in the Eric Garner case is that with these reforms, prosecutors would have had an alternative means of scrutinizing the conduct of the officer and determining whether or not the amount of force that was used against Mr. Garner was grossly in excess of what was warranted under the circumstances. These reforms will not only help us to hold police officers accountable for wrongdoing, but I believe will dissuade officers from using unnecessary force in the first place. And this is not something that is new. This is not a unique approach to the use of force. On the federal level, you have the George Floyd Justice Policing Act, which has passed in the House, includes, among other things, a requirement that officers only use lethal force as a last resort, and new reporting requirements about the use of excessive force by law enforcement officers. On a state level, my colleague in New Jersey, State Attorney General Grewal, recently took action to amend the state rules on use of force to ensure lethal force is only used as a last resort. And earlier this month, the city of Sacramento, California, passed a last resort standard for police use of force. And in the state of Washington, they also took similar action. Police officers are imbued with the incredible amount of police power and state power, and the state has every right to demand that that power is used as seldom as possible, and when it must be used, only appropriately and proportionately. We need real accountability and clear standards for when that use of force is acceptable and when it is not. We need real consequences for when an officer crosses the line. And while this legislation is certainly not a cure-all for all of the ills of our criminal justice system, it is a critical step forward. But there is much more work to be done. And so we are also examining and beginning to engage in conversations about mental illness and ensuring that mental health professionals are responding to situations where their expertise is needed, and other areas of reform. But today we are introducing this policy. And while there will be no justice as long as groups of people in this country are unequally killed, my hope is that today with this legislation, we can provide clear and concise and objective standards. We are yet another step closer to the fairer and more equal justice system that we all deserve, but most importantly, that is required under our Constitution and our law.